Let's resolve this issue about the penalty phase proceeding if it's necessary. Let me just ask, state first, how long did y'all's presentation going to last? Roughly.
The state's entire presentation will consist of 3 or 4 victim impact statements, which I still plan after working everything together and provide to everybody.
Need a ballpark figure. In the defense, how long do y'all think your presentation will last?
2 days.
Now,
there's a rebuttal, obviously.
I understand. Now, Mr. Bagadal, what is it y'all need to do as far as preparing for defense witnesses and so forth we talked about earlier?
Okay, so September 4th, we received those 2 witnesses, one who has been removed from the witness list, and then this doctor, or this Mr. McAndrews, who is some type of former prison warden. I anticipate that that's going to require a proffer because I'm highly suspect of the relevance, and the disability of his testimony. So that's going to drag that one out a little bit. But I haven't done his deposition yet, and I need to do that. Dr. Gabarino.
What's his first name you said?
I don't know what it is. Ronald
McAndrew.
Okay. All right, go ahead.
So I've got to get that deposition scheduled, and I was hoping we could get that done Monday. Dr. Gabarino's deposition is scheduled for 10 o'clock. What's today? Thursday. 10 o'clock Saturday. So that's another probably couple hours because he didn't allocate enough time for his initial deposition. I've got to get that transcribed. I've got to get that to Landrum. I've got to get Dr. Landrum out to see the defendant. And now, for the first time, 2 years and 7 months after the murder, the defense is saying on the record that they don't think Dr. Landrum should be allowed to see the defendant. So now apparently we've got to litigate that issue as well. With that in mind, it's Thursday afternoon and we're not working tomorrow. And if we get a verdict tonight, the 48 hours pursuant to the rule would run, through Saturday. So Sunday is when I would be hoping to get Dr. Landrum out there, and maybe he wouldn't even be available. So maybe it would be Monday. So then I would assume the defense would want to conduct a deposition of Dr. Landrum. And I guess that is where I'm at. So, I mean, if we started on Wednesday, in my opinion, that would be the earliest possible date that we could start. And that would be
what day?
Wednesday. That would be really cramming it in. And I would just, again, I've said over and over from the beginning as we've addressed this issue that I would like a week. And I think that my client, the state, is entitled to prepare. Just as the defense asked for time to prepare for jury selection and all the other issues that they have. So that's the best estimate I can give you, Judge.
All right. Ms. Saldana.
Judge, well, Ron McAndrew is available all day tomorrow. I don't know.
Great.
He's waiting for us to let him know what time for that deposition, so that we hopefully can take care of. And we talked to this jury originally, and we gave them the date of the 9th of October at the latest. So I think that this long weekend we should be able to wrap up those 2 witnesses that he needs to finish up with the depositions and start on Monday. We don't need any more time to get prepared, Judge. And according to the whole issue that involves the state having an expert go and evaluate Mr. Tisdale, according to the rule 3.202D, they can only do such evaluation if the defense files a notice of mental health experts. And we did not do that notice. So I don't know where he's reading that they have the right to have their expert go and evaluate our client when we are not presenting any mental health mitigation.
Well, let me just ask this thing. Has Dr. Gabarino or this Mr. McAndrews tested, evaluated, examined, or interviewed the defendant?
Interviewed. All of our doctors, well, Ron McAndrews is not a doctor. He met our client at the That's all. We've met our client as well as Dr. Gabarino has met him and interviewed him, as well as Dr. Cunningham has met him and interviewed him.
No, is Dr. Cunningham not going to testify, or he's not going to testify?
He is going to testify, but the state has already deposed him, so he doesn't have an issue with that.
Okay.
Right, I deposed him, but he's a mental health expert.
He's not testifying in as far as any mental health evaluation testing that was done. The purpose of him is for prison adjustment, and Ron McAndrews has to do with prison life, and Dr. Garbarino has to do with, Ms. Marina, can you explain to Dr. Garbarino?
Let me just, if I could help, perhaps with the law. That might be-
Let me just hear what this is about, because they wouldn't, I just want to know what,
Dr. Garbarino is,
give you another chance.
Yes, Dr. Garbarino's testimony will have to do with his studies in development, child development, social factors that influence that.
Right, that's what psychologists do. And I would add that
the testing was done, Mr. Bacaroff.
Well, the rule says tested, evaluated, or examined.
Okay, well,
Has he tested, evaluated, or examined?
and our client has not had any of them done with any of these individuals.
Okay. Mr. Bagadol, any other comments?
Yeah, Judge, if I could cite you to Eldridge, V-State 706 Southern 2nd 1340, where the Florida Supreme Court allowed the state to use the results of a held mental examination to rebut an expert on future dangerousness. This guy, this Dr. Cunningham, who is he travels the country testifying on behalf of capital defendants about a number of things, but not the least of which is whether or not they are going to murder somebody in prison, basically what they're saying, is dependent in part upon his examination of the defendant, of his interview of the defendant. See, that's what psychologists do. Psychologists meet and they conduct a clinical examination. That's what those meetings are. So it's an evaluation pursuant to the rule. It's just, here's what's the most disconcerting about this and the most disingenuous and dishonest portion of the defense argument, and that is, we've known this for 2 years. And now, on the eve of the penalty phase, they're telling me I can't get Landrum in this. I listed Dr. Landrum 2.5 years ago. So, I mean, it's just, I'm at a loss.
We've never done the notice, because if we had done the notice, I would be right there with Mr. Bacaroff. We never did the notice because we did not intend on having anybody.
Here's the problem, though, for me. Y'all are saying it's not expert testimony of mental health professionals contemplated by Rule 3.202B. The state says it is. And they want, as I understand it, they want their Dr. Landrum to examine him just in case pursuant to Rule D. In other words, what if I hear this testimony and I determine it's expert testimony of a mental health professional? I don't know, it may be. That's what their point is.
Judge, if the court wants to proffer their testimony, but we did not have them evaluate them. Dr. Cunningham said in the deposition with Mr. Bacaroff that he did not perform any testing on him, an evaluation, that he interviewed him. I don't know where we can go with that other than to tell you that we did not ask our doctors to perform any of those in-depth evaluations in that capacity.
Let me just step off a minute and I'll make a decision in just a minute.
Can I tell you one more thing? That Dr. Cunningham's deposition has been transcribed, as is Dr. Gabarino's, part of it. Why don't you take a look at those? I think that will give you some insight into what they do and what they did. And I also want, for the record, to cite you to Hickson v. State at 630 Southern 2nd 172, which is basically the case which caused the creation or resulted in the creation eventually of 3.202. But I can make you copies of those.
Have the depositions, or can you have them with you? Or?
Well, I got 1,500 people back here. I'll send them back and make copies immediately.
And Judge, the issue with Dr. Cunningham's deposition and maybe with Dr. Gabarino's is that, of course, in deposition, Mr. Bacanal expanded the deposition to include all kinds of issues that Dr. Cunningham could have gone into, and if he were to evaluate Mr. Tisdale, although he answered questions, but he said that he could not testify to that because he wasn't hired to do that type of testimony in court for this particular case.
I'm going to say this and we're going to stop. I'll let y'all present to me whatever you want to present to me. The issue I have to anticipate is if I understand the defense hasn't filed the notice, as y'all's position is this isn't mental health professional testimony regarding statutory or non-statutory mental mitigating circumstances. They say it is.
Because he expanded the deposition to include all the expertise that he's done over the years, but we are not having him testify to those things in our case.
Okay. They don't agree though.
Well,
so here, if I determine that it is mental health, and I'm not saying I am, but if I determine it's mental health professional expert testimony and no notice has been given, then what?
Judge, the court needs to make a ruling.
But then what? I mean, I'm going to do that now to try and solve all this.
We will
ahead
stand
of
by our position that it is not.
You may be
going
right.
to be.
You may be right. But so I'll try and reconcile this in just a minute.
I've got Dr. Cunningham's deposition in my computer. I'm going to email it to
Okay.
Alice, I guess.
And that's it. I'll be right back. Y'all have to be patient. call their family to let them know, or check, one wanted to check on their son. One wants to cancel dinner or will be late. One wants to call her husband, let her know she's staying. So one is Ms. Lauk, one is Ms. Stottlemyre, and one's Ms. Gettler.
So now,
Sure. Who? Oh, all right. Hold on, she's not here. Hold. For the record, all counsel present, defendants present, the jury's outside the courtroom. Okay, just for the record, Ms. Lauk sent in a written note. She wanted to check on her son. Ms. Stottlemyre wanted to call her husband, let her know she's here. Ms. Gettler wanted to cancel dinner or will be late. Any objection with them being allowed to contact their family?
No.
I'll have one of the officers stand by to make sure they don't talk about the case.
Whatever procedure the defense feels is appropriate is fine with the state.
I agree with the thought.
Okay, I'll let them make a call. I'll have one of the officers stand by to make sure there's no improper communication. I'll come back in a minute and resolve the penalty phase issue if you'll just bear with me, please. Okay, we'll go off the record. Thank you for bearing with me.